Disney has lost its case against the Central Florida Tourism Oversight District and Ron DeSantis in the federal lawsuit. This is the famous First Amendment lawsuit in which Disney came for Ron DeSantis. They said their First Amendment rights were violated. Well, we're going to get into that today on The Legal Mindset. Now, I have provided a full breakdown in a live stream on this final conclusion, this motion to dismiss in the federal case of DeSantis versus Disney, or rather Disney versus DeSantis, because remember, Disney was the plaintiff. But this is intended to be a summary version, quickly breaking down the basics of this dismissal of the federal claim, which has been much lauded by the Disney show media and the pixie dusters as something that was going to end everything. It would ruin Ron DeSantis. And everyone on that side of the scale thought it was a shoe-in, a slam dunk, a clear case. Those out there in YouTube shill lawyer land that know nothing about this, nothing about Florida law at all, said this was a perfect case. It was perfectly written. It was definitely going to happen and be a W for Disney. Well, we're finding out, in fact, it was not just an L, but it was an absolute non-starter. This has been issued a motion to dismiss. Now let's just start with what a motion to dismiss is. A motion to dismiss is the very first stage at which a claim can be ended, which a claim can be gotten rid of. It's saying at this point that you don't even have enough facts to support a valid claim here. And under a motion to dismiss, all facts are taken in favor of Disney, in favor of the facts of the party against which the motion is pending. So since Ron DeSantis, the secretary, the CFTOD, all of them were trying to dismiss this, they were the ones trying to file these motions to dismiss. Well, Disney and the facts that Disney put up were taken as favorably as possible. So the judge is looking at them in the light most favorable to Disney, assuming everything Disney said was true, which, by the way, I can tell you factually is not. Disney is, well, stating a lot of BS. Well, they found out that both in regards to the governor and in regards to the CFTOD, the case must be dismissed, and for exactly the reasons I've been saying for a year. But there's different reasons for the governor versus the CFTOD. So let's start with the governor. Well, the governor was claimed to have passed this law in a way that was impermissible. But the real question is, for standing, is there a possible thing this court can do that would stop the governor or the legislature from doing what they're doing in the future? And this court conclusively answered no. There is nothing you can do to stop a special district from being created or destroyed. The state, as it says clearly in the case, the legislature can create and destroy special districts. They control everything regarding this. And remember, back in the day, this was all about the experimental prototype community of tomorrow. They promised that. Well, we never got that. And for that reason alone, they could break up the district, or any legitimate reason to break up the district and disband it completely. That was entirely within their power. Well, they didn't do that. They actually reformed it into the CFTOD. But because of that, because, hey, look, this is something that anybody can do, that the legislature can permissibly do. And not only that, but the board members, those board members that were appointed, well, they could be appointed by anybody. They could be appointed by anybody, anywhere, anyhow. This is something that is not something that is just restricted to Ron DeSantis. These members could be appointed by the legislature themselves. In fact, the Senate has to confirm all of the folks that are nominated by the governor. So in this case, there's nothing to stop the future valid action of the board, or rather the legislature, because the legislature could just pass another law, simply pass another law recreating the district. And that would be completely legitimate. And because there is on its face multiple legitimate reasons, although just one is necessary, there's no standing against the governor because there's no way for a court to redress the ills, the proposed ills of Disney. There's no redressability. So they tossed it out against the governor as well as against the secretary, which was a weird person to add because really all the secretary does is maintain this official list of special districts. It's really a minor ministerial task, but there's no case there either because, well, there's nothing for them to really do that would change one way or another regarding the list of districts. So they failed there. Now, against the CFTOD, they did indeed have standing. So there was standing to try to address grievances against the CFTOD. But there was no claim. There was failure to state a claim. There's no single action that the CFTOD did that was wrong here, and nothing that they could change or really do to change what the CFTOD does as the CFTOD versus our CID. And furthermore, Disney is not the only person. They're not the only taxpayer within the CFTOD, within the Reedy Creek. There are other taxpayers. Now, yes, they are the largest taxpayer. Disney pays the most taxes within the CFTOD, but they're not the only taxpayer. It's like living in a small town and you're the richest guy in that town. Well, just because you're the richest doesn't mean you get total control. It doesn't mean you are that thing. It doesn't mean you are Reedy Creek. No, Disney is not Reedy Creek. They are the largest landowner. They were the one who got to elect the votes because that was how the system was, but that doesn't mean it's the same thing. And the bill doesn't mention Disney at all. In fact, it doesn't touch Disney at all. It doesn't mention Disney at one bit specifically. It mentions only Reedy Creek. And therefore, there's no claim for them in terms of actual damage as Disney. Disney is not harmed here. So therefore, this First Amendment falls flat. The argument for First Amendment falls flat and must be dismissed. And therefore, as we can see, the judge came to the conclusion that I came up to a year ago saying this would be dismissed under clear Florida law because this is entirely outside of the control of an individual, or rather an individual corporation. This is a government. This is a government that controls multiple landowners, that controls multiple businesses. It's not just Disney. Disney is not Reedy Creek. Reedy Creek is not Disney. These have to be separate under Florida law, and that's what the judge properly in this case concluded. Now, Disney said there may be an appeal, and oh boy, do I hope there is an appeal. And also make sure to stay tuned on this channel because there will be a conclusion to the state case, which is still going on regarding those 11th hour last minute agreements that were passed by Disney. This is far from over, not to mention potential criminal cases that can be brought against former members of Reedy Creek. This is something that goes deep. This is something that is going to be going on for a while, and we will stay tuned to it on this channel. Please make sure to like and share out this video with anyone who's interested, and I will catch you all later.